Hello and welcome to LiveLaw. We are gathered here today to speak about the recent marriage equality judgment of the Indian Supreme Court. As we are all well aware, on October 17, a 5-judge bench of the Supreme Court of India in Supreo versus Union of India refused to grant legal recognition for queer marriage in the country. In the days that have followed, the judgment has received a lot of backlash from different segments of the society, with many people, especially from the queer community, expressing disappointment with the judgment and also demanding action from the political class on the queer community's right to marry. Today, we are joined by 4 esteemed panelists to have a conversation about this judgment. They are lawyers, activists, academicians, and most importantly, they are people who are concerned about the rights of the Indian queer community. So before we begin our discussion today, I will take the honor of introducing our wonderful panelists. We have with us Muskan Tibrewala, who is the Assistant Director, Law and Marginalization Clinic at the Center for Justice, Law and Society. Prior to this, Muskan has also worked in litigation with the chambers of Advocate Karana Nandi and has even assisted the petitioners in Supreo versus Union of India. We have with us Aishwarya Singh, who's a lecturer and Assistant Dean of Clinical Legal Education at Jindal Global Law School. Aishwarya read for Bachelor of Civil Law at the University of Oxford and has also worked as a judicial clerk for 2 years for our current Chief Justice, Dr. D.Y. Chandrachud. We have with us Kanmani Ray. Kanmani is a queer rights activist and the first transgender lawyer enrolled with the Madras High Court. And finally, we also have with us Karan Tripathi, who is currently pursuing his PhD from the University of Cambridge. It is such a pleasure to have all of you with us today. And let's just get started with the discussion now. So now, as we all know, that this judgment, which runs for around 366 pages, addresses different aspects of queer rights in India, be it the right of marriage or civil unions or even adoptions for that matter. So in this discussion, we will be addressing each one of these rights, and let's get started. So one thing that the bench has unanimously held is that there is no fundamental right to marry. But the minority opinion has also stated that even though there is no right to marry, but this bouquet of rights, which comes with the institution of marriage, that has to be guaranteed by the state to all the queer couples. And therefore, civil unions should be legally recognized. In this context, what really is the difference between the right to marry and the right to enter a civil union? And why has the court unanimously refused to recognize the right to marry? We'll start the discussion by Aishwarya throwing some light on this aspect of the judgment.
Thank you, Padmakshi, and I'm so happy to be on this panel with such distinguished panelists. It was quite unexpected, I think, in most quarters that the Supreme Court refused to hold that there is a right to marry for queer couples or otherwise, because it kind of goes against its very flexible jurisprudence, where it kind of recognizes these unenumerated rights under Article 21. This has specifically been seen after emergency, where the court under Article 21 has read multiple rights: right to shelter, right to food, right to development, right to know, right to travel abroad, like numerous rights. So it was kind of surprising that the Supreme Court held that there is no right to marry. And the Supreme Court in this judgment constantly held that there is a right to choose your partner, but as a logical corollary, it still refused to say that there is a right to marry. And many commentators have said this, and I also feel that the court actually created certain new tests to now determine if an unenumerated right can be recognized under Article 21. And for example, Justice Bhatt in his majority opinion says that because marriage is a social institution and it has nothing much to do with the state, that's why there cannot be a right to marry. And the Chief Justice in his minority opinion completely contradicts Justice Bhatt and says that because marriage is an institution which is so heavily regulated by the state that it has achieved social and legal significance because of state regulation, it cannot be a fundamental right. So basically, the minority and the majority contradict themselves when it comes to deciding how do we define these unenumerated rights under the fundamental rights chapter. And as I said, it also kind of goes against the flexible jurisprudence the Supreme Court had established towards recognizing these unenumerated rights. Now, we can have this sort of discussion, this academic debate, and even a debate within queer politics as to whether we want marriage to have this fundamental status, whether it should have that elevated status over other relationship forms. Because if we are demanding right to marry, we are still establishing this sort of hierarchy between marriage and other forms of relationship. But that aside, what the Supreme Court does in this particular case when it comes to right to marriage, it appears that there is a lot of inconsistency with its previous jurisprudence, and it also creates this apprehension whether the court came up with these new tests specifically to kind of defeat the claim of marriage inequality, and that's a very discomforting thought. The majority basically says there's no right to marry. It also says that queer couples do not have a right to civil union, but the minority says that there is a right to civil union for queer couples. Now, what entitlements flow from this right to civil union are not really defined even by the minority judgment. It kind of hints at what sort of entitlements may flow. You can get access to ration card, some next to kin privileges, visitation rights in hospitals, maybe even succession rights. But even the minority opinion leaves, the delineation of these entitlements that are to flow from the civil union to the executive. One thing that the minority opinion does is to say that queer couples will have the right to adoption. Right. So this is what the minority opinion does. The majority says that no, like right to adoption will not be given to queer couples under the setup of civil unions. But this is what the minority opinion does. For me, what is interesting is to see how the minority comes up with a civil union, which obviously no one argued about. The petitioner did not want a civil union, right? But still, the minority opinion came up with this under freedom of association, freedom to have intimate associations. What I'm interested to see is how this freedom to intimate association would be developed further. Can we think of this beyond marriage, beyond coupledom? This is something that the minority opinion also does not engage with. But can we develop it further in other litigation to see if this can mean the right to chosen family? So this is what I'm interested in. Yeah.
Aishwarya, an interesting point that you raise is that the petitioners did not ask for a right of civil union, so to say. So is this something that the queer community at large, would you say that they did not really want the right of civil unions, so to say? Because I remember that when I was watching the proceedings live, there were a lot of advocates on behalf of the petitioners who had repeatedly told the Supreme Court that civil unions is not something that they wanted. So let's hear Muskan on this aspect.
The arguments of the petitioners in the case are very much hinged on also the fact that the reason that we want the right to marriage is because it gives us these rights and entitlements. But it's not solely just that, and this is something that both the majority and the minority judgments agree on, is that marriage itself as a social institution, and I think Justice Chandrachud calls it this hidden law, right? He says that letting you into that institution is something that gives you a lot of benefits in society. I think Justice Bhatt also says that that we get that you feel left out. So this is something that the court recognizes, that it's not just about the benefits, but it is also this institution which has a recognition in society, which the petitioners believe that queer people also have access to. And curiously, the question is, even if you don't find the right to marriage under Article 21, why do you not think queer people deserve the same rights as heterosexual people? So why not under Article 14? And this is something that you see Justice Chandrachud does with his analysis of the constitutionality of the adoption regulations, where he says there's no right to adoption under 21, but he finds it unconstitutional under 14 and 15. So even if there's no right, why can I not be treated equally? And that is what the petitioners were asking for. And I think it's not been answered as well as it can in our current jurisprudence by this court.
That's a very interesting point that you raised, Muskan. I also wanted to talk about how the majority opinion has stated that marriage as an institution comes from custom, right? So that's why there was a custom of marriage which was formed, and then that was recognized by state, and therefore the judiciary cannot really step into it. So, Karan, I would really like to hear your opinions on whether this recognition of maybe like other customs as evolving rights is different from, let's say, the custom of marriage, which is now not recognized as a right at all. Karan, I think you're muted.
Sorry. Hi. I think I really like the point that Aishwarya made about intimate associations, and that it's very interesting to see that how the jurisprudence on intimate association develops, because it's will it also open up to the different forms of intimate associations that queer people have or they desire, or whether it will also be shaped by how intimacies are experienced and desired by cis heteronormative people. So it's interesting to see that, because we have seen how marriage has been interpreted as cis heteronormative. They have completely excluded the alternative ideas of marriages or desires of marriages in the very definition of marriage. I think the court was beginning with an understanding of marriage which was cis heteronormative. So I would say that they didn't even sort of choose to open up the understanding that there can be a conception or a desire of a marital relationship, which is not wedded to the idea of the marriage that exists right now. And I think that's also problematic to an extent, because then the question became that we are trying to enter into a space that is not ours. We are trying to enter into an institution that is been close to us, instead of whether that the institution must grow to also accommodate what we want. And so if in the first approach, it's easier to shut your gates and be like, I'm not letting you in this institution. But in the second approach, the institution has no other choice but to extend its balls to the others. Otherwise, the institution will be questioned. So I think the very approach or understanding of marriage that the court had, which it sort of underscores its analysis, is a very cis heteronormative idea of marriage. But also this point on we don't want civil union and we want marriage, and whether the court gets to decide, okay, I won't give you the right to marry. And this is particularly to the minority judgment, that we will not give you right to marriage, but we give you right to civil union. It's I feel like that's not the job of the court to decide. I mean, I feel like that when the petitioners knew very well that this petition is not, it's seeking a space in a structure which is not very queer friendly. It's just seeking a space there. It's not challenging the structure. And I think having that understanding was important. And had they had that understanding, they would have evaluated this under the 14 and 15 jurisprudence instead of 21 jurisprudence. But they didn't. So I mean, for me, the idea was what the court should have simply seen is that the petitioners are not trying to question or challenge the structures of intimate relationships, but simply saying that there is a structure of intimate relationship that exists, and we want access to it, and that structure is not giving us access, and that's why it's a discriminatory issue. So yeah, I feel like that those things were very much problematic in my view, and I feel like that the approach of the court was very paternalistic in a way that, you know, even if the petitioners said that we don't want civil unions and we want access to something that is called marriage, then if the adjudication should be on that okay, you can say we are not letting you into that institution, but you should not then go ahead and say, oh well, but take this as a consolation prize, or like take that as a consolation, because then it's like you as an institution are deciding as to how we ought to think about our desires and as to how we have to think about our intimacies, which is not your job as an institution. So I think those are some of the preliminary comments I had on these questions that you asked. Also, like very quickly, when you talked about, sorry, yes, just,
No, please
sorry,
go.
continue.
Karan, please go ahead. I'm so sorry I interrupted you.
No, I mean, I feel like that even, first of all, I really didn't know that, I really don't think that the court really had to go into this question of whether there is something called right to marriage that exists. But also, like when they say that it's a customary practice that the state has recognized, that does not say that that's the only customary practice. It's just that that's the customary practice which was largely recorded and largely practiced. And the second thing is that state giving legitimacy to a certain customary practice does not allow the state to render other practices illegitimate. And as a constitutional democracy, we need to think about that. Do we want to give that power to the state to very selectively recognize and selectively legitimize certain practices and completely ignore as other practices as if they don't exist? And I think a lot of historians and queer historians and other historians are working and have worked on highlighting how queer relationships and queer intimacies have existed for so long, and these practices have been there. So again, like I think the very definitions under which the court was working were very cis heteronormative, and when you're working through those definitions, I don't think you can ever do justice to the queer community. I mean, I don't see how that flows.
That's really, really interesting to note that the court should have reimagined the right to marry as not a heteronormative institution, but as an institution which is more inclusive for everyone. And so I would also invite comments from Kanmani regarding right to marriage and how does she see it fitting in our existing legal.
So my preliminary remarks on the entire marriage equality petitions would be that I'm in a very, ever since the judgment came out and even before that when the petitions were filed, I've been mentally in a conflict because I particularly did not agree with the entire set of people going to court. While everyone has a right to go to court and you can petition the court at any point for your fundamental rights violation, as a person who has been involved slightly at a smaller level in whatever trans rights activism keeps happening in the country, I particularly was feeling like, okay, but wait, petitions were filed, but then everyone else doesn't even know that the petition has been filed, and what do we do now? So either I must say a lot of the petitions which were filed after that were either under the impression that they have to join in or they have to be left out, right? So while I mean this entire strategy of going to court, I have not been very much in agreement with, although the strategy of going to court has always helped the community for a long time now. Now, having said that, I would agree with Karan with the point that I don't know why the court went into the whole idea of whether there is a right to marriage, whether there is not a right to marriage. And I don't agree with Justice Butt's reasoning about going into the object of, why Special Marriage Act was enacted in the first place. I don't understand maybe I'm new to the profession, so I can be corrected, but when a law is created and you have consistently given verdicts in Nalsa, in Navtej, in Chef and Jahan, where you have upheld fundamental rights, and you have in fact gone ahead and created new rights. You have read new rights into the fundamental rights. I mean, right? I'm borrowing from what Mihir Sampson was saying in another panel, but I agree with him. Is in the idea that right to self-determination of gender identity is part of Constitution, but it was read into the Constitution more explicitly while we say it's implicit, by the court. So then we can keep saying that, certain laws were not framed with certain objects, and hence it's not discriminatory. And even if it's discriminatory, we don't want to go ahead. But it doesn't hold water anymore, I would say. But I kind of do agree with, since I put ahead my disagreement in the first place itself, I would agree with the fact that, yes, it's messy. Yes, it's difficult because the entire set of personal laws is not easy in terms of my family and marriage, etc. But the other point I don't understand is why, while the judgment very nicely goes into both, all the judgments goes into, marriage and the foundation of marriage and its, origin in being extra legal, a lot of rights that we see in the Constitution today are of extra constitutional origins, right? And marriage as an institution has been regulated. The Special Marriage Act came in at a point when, people were fighting, saying that marriage should not be regulated, right? And people had a huge issue with it back then in 1800s. Now we have Special Marriage Act, we have Hindu Marriage Act, and Dr. B.R. Ambedkar resigned over those bills, in fact. So I really don't understand going into this idea that if we have to go into that idea, marriage actually, at least I would say, I would make a controversial statement here, but it's the truth. At a predominant level is about caste. Is about caste endogamy. It's about preserving your caste endogamy. It's about passing your property. It's about your legacy. It's about patriarchy. So then this, I don't get that point. And I was half expecting that a declaration would have happened, at least, of the right to marry, or at least that these rights are, these laws are discriminatory. But they have entirely just gone ahead and said, no. Even despite their internal disagreements, and it's interesting, this judgment has so much internal conversation between the judgments. Justice Chandrachud responding to Justice Bhatt responding to Justice Chandrachud, and that's quite good. And what they have not, for example, very explicitly said in Nalsa and Naptej, they have gone ahead and said in the obiter part in this place. That I'm very happy about. So I would say, in that sense, it's positive, but in a lot of sense, it's negative. So with that, I think that's my opening comments. I would say the next section is on Special Marriage Act. And if anyone who doesn't understand this, who doesn't know the Special Marriage Act, it came about in 1954. It's broadly a regulation of marriage for those who want to enter marriage belonging from different religions. So for interfaith relationships who wanted recognition of marriage, this was the law. And interestingly, there's a notice period in Special Marriage Act. And that is one big point of contention, which doesn't perhaps exist much in other personal laws.
Thank you so much for introducing the Special Marriage Act for us, Kanmani. It's very pertinent to note that the court refused to enter into the domain of Special Marriage Act, saying that, citing the doctrine of separation of power, or even citing complex workability, saying that, Special Marriage Act was interconnected with so many other laws that the court could not enter that domain. It's also very interesting to note that the CJI, when he, in his judgment, had stated that India did not follow the doctrine of separation of powers in a traditional sense, right? But, and I'm very interested to know what our panelists think about the application of the doctrine of separation of powers in the judgment and in deciding not to legislate on queer marriages. So let's have comments from Muskan on this aspect of the judgment.
So a lot of the judgment talks about, for example, Justice Bhatt talks about how there is no precedent whatsoever of the court creating social structures. When, for example, in Nalsa, they did that. The Supreme Court said that there is the third gender, there is this identity of people that have not been recognized in law that need to now be recognized. in terms of, we were talking about customs also, right? So we were talking about whose customs does the court think is worth being given legal recognition? And in terms of even the customs of trans communities, like of the Hijra Gharanas, the court has recognized this in succession laws. So the court, in the domain of family laws, has recognized social structures, given it legal recognition before. There is precedent for this. So why could it not do it this time? There is this over-reliance throughout this judgment on the fact that there needs to be a statute, that marriage has always been regulated by statute. And so the petitioners are asking us to do something that we cannot do under the Constitution. But the Constitution has always been used to interpret the idea of marriage. This is how the democratization of marriage, as Justice Chandrachud calls it, has happened over the last few years. We have always interfered in marriage, whether that's in Joseph's Sign, where you talked about the autonomy of parties in a marriage, whether it's the court doing irretrievable breakdown under Article 142 when there is no legislation prescribing this. So when the court has interfered through the Constitution, the other odd thing is also what they say about Shafeen Jahan and interpreting the existing jurisprudence on right to marriage, saying that these were under existing laws. If they were under just existing laws, then the court wouldn't have needed to go to the Constitution. But you did go to the Constitution and derive that right from the Constitution. So why can you not do it here? So in terms of that, in terms of saying that the court has not gone out of its way, used its extraordinary powers when there is minority exclusion, when there is a violation of the Constitution, which the court has recognized is not a violation of the doctrine of separation of powers and has done this over the last few decades, seems a little just trying to avoid something that they don't want to do at this point, because it's just thoroughly inconsistent in the court's jurisprudence.
So would you say that the court could have perhaps framed some guidelines to direct the union to act in a certain manner? Or is it completely out of the court's jurisdiction to do any of that? I would invite comments from Aishwarya on this aspect. You're muted, Aishwarya.
Yeah, so I think first I'll start with this point that there is this general incoherence with the court's jurisprudence. So sometimes the court will engage in very expansive interpretation where you might feel it's actually kind of transgressing into the legislative domain and kind of interpreting provisions of a legislation that kind of go contrary to the legislative intent. And it will also transgress into executive domains and do all of these things. But then suddenly, as we see in this judgment, the court will be like, okay, this is something that we cannot do. This is just too much for us. The magnitude of the task is too much for us to reinterpret all the provisions of the SMA to make them applicable to non-heterosexual couples or unions. So there is this incoherence, and that's why when the court says that it cannot judicially legislate in this case, it seems odd because it has done it before. So Vishakha is one example that everyone gives where there was this legislative vacuum where there was no law on sexual harassment and the court came up with its guidelines to govern that legislative space. Even with NALSA, the court came up with expansive guidelines on how there needs to be a regime for recognition of gender identity, self-determined gender identity, and it also gave certain other directions regarding certain welfare entitlements that should be given to trans persons. So it has done all of these things before, and now it stopped short of doing it. So that just tells you that court is also a political institution after all, and it makes these choices in a case-to-case basis, and there doesn't seem to be a principled institutional position of the Supreme Court on these issues. And this arbitrariness is sort of disappointing in a lot of ways. So yeah.
Interestingly, while the court did not frame any guidelines, it did direct for the union to form a committee to look into the rights of queer persons. So, Karan, what would you say? Is this something? What are the expectations, do you think, as per you, do the queer community have with this committee that the union will be forming? Let's talk about that. Yeah.
I mean, will they be forming it? I really don't know, and I think even if they do, I mean, the last knowledge I have of a union formed committee was the committee formed for reforming the criminal laws, and we all saw how that went. So I think one of the reasons why this, I completely agree with Kanmani where they point out that it was a very messy move. Not the many stakeholders in the community were not discussed, were not engaged with before filing the petition, which is also a flaw within the community, as they believe that there are certain people who can act as spokespersons for what the community feels. So that's having said that, the reason why the petitioners went is that they somehow knew that whatever little bouquet of rights we have come from judiciary, and more, there is one thing that a state actively discriminates, and there's another thing that is the state completely invisibilizes. When the state actively discriminates, it somehow recognizes your existence. It recognizes you as an object on which the state can exercise power. But when it completely invisibilizes you, then you're not even alive, you're not even human for state power to be exercised on you, which is, I think, even worse. And that's what the state policy has been on queer people, right? So, like, the state has even have not used the words LGBTQI plus in legislations and in policies, or even if they have, I haven't had a politician or a minister talking about policies and using the word lesbian, gay, or trans. So you see that how there is not acknowledgement, there is complete invisibilization, and that allows the state to to not do anything. So I think the court completely ignored the reason why the petitioners came here and not Jantar Mantar or like any political struggle in the first, and it completely did not acknowledge it. And it's very disrespectful, I would say. It's very disrespectful, it's very Orwellian, it's very, I don't know, naive. I mean, I'm really like toying with, I don't know, judicial. What is it called when you go against judiciary and then they contempt? So I'm very so with due respect to the court and to the institution of judiciary, but I felt like that. I mean, read the room, read the room. I mean, there's a reason why we came to the court and we didn't go to the parliament or we didn't protest. And of course, it's all. I mean, they did direct them to form a committee, but nothing else. No timelines. Who would be the part of the committee? How the discussions are going to happen? When the report is going to come out? So it just. I don't know. I think it would have been better had they not asked the committee to be there. That's see. Overall, I really did not like this approach. That I found that extremely infantilizing. That, oh, we love you, we care about you, we want you to exist, but we're not going to give you rights, and we want the government to take decisions. I said, don't do that. I would rather want the courts, the judges or the court to kick us out with an iron fist rather than sort of uh, rather disguise that iron fist in flowery gloves. So I personally felt that it's useless. It's not going to serve any purpose. I mean, I personally have no optimism when it comes to that committee being formed or doing anything. And I personally felt that it should not have been the part of the judgment. I don't think that courts uh, I mean, someone tweeted that, oh, we have a hotline now. So what do we do with the hotline? So we don't need hotlines. We don't need, your sympathy, your nice words, your acceptance. We need our rights. We need justice. And if you can't do that, just reject it. Just don't sugarcoat it. So I believe this idea that constitute a committee and do that is just I found that very, very disrespectful, and I found that should not have been there.
Definitely, there being no framework established for the committee or any guidelines on how the committee was to be formed or any deadlines, so to say, is, I think, very visible in the judgment. But when you talk about acknowledgement, it brings me to another point that the court has unanimously held that transgender or intersex persons in heterosexual relationships do have the right to marry under the existing legal framework. So is this, let's talk about whether this is a right which already existed, or so, like, was it acknowledged by the court now and it already existed, or is it a new right which has been created by the Supreme Court? So Kanmani, what are your views on this?
It's interesting, in fact, because they have, what they've held is basically that transgender persons who are heterosexual can marry under existing marriage laws, given that everything else falls in place, right, as per the restrictions under the marriage laws. Now, it's a matter of interpretation of NALSA that already transgender persons have gotten married and gotten into heterosexual marriages, right? Now, the point is, when it comes to transgender persons, some of the arguments that were made and on the ground, what I have seen over time is that transgender persons who have already gotten into marriages, forced into marriages, right? Where they were forced to be cisgender and not be who they are, those marriages are either subsisting, are the marriages, the entire legal validity of those marriages are into question, it's just in limbo. They have not nobody has gone to court to contest it, or some have gone to court and contested. All that is there. I would say the Transgender Persons Act 2019 was already passed. It has very clearly laid out, the process for recognition of someone as male, female, and a transgender person, and that makes it fairly clear. It doesn't have to be repeated. I'll give you an example. I gave this example in another panel that I was part of, and I heard this again from someone else. And when I Googled and I came to know, is that the judgment of Justice G.R. Swaminathan, where they have recognized an intersex trans woman marrying a cisgender man, Arun Kumar and Shrija. As far as I know, the last information that I know is that it was 3-4 years and they did not still get the registration certificate. The judgment came in 2019. And it was 2023, as far as I know, at least a few months back. At least that's the information that I have. So I'm again in the conflict. While I am happy that it has clarified, it is not new. It has already been clarified by other high courts in already existing judgments. And it doesn't, it just feels like, oh, fine, if you're heterosexual, please enter into marriage, you have full rights. It's a matter of interpretation, we are willing to give it to you. We have already read that as part of fundamental rights. So as a trans woman, if I get married to a cis man, fair enough. I'll have all rights. Thank you. But at the ground level, a lot of couples, trans persons in the couples are separated. They face violence. The police doesn't recognize their union. This is a very real ground reality where the police are saying, oh, no, your marriage is not recognized. How are you even saying you're the wife? How are you even saying you're the husband? Right? We know a lot of trans couples face a lot of issues where they are, kidnapping cases are foisted on them by the parents, by the trans person in the relationship, all sorts of things. But I don't see, while I welcome this, statement at this level of the Supreme Court, I don't see how this will work, in the sense that, going back to the previous point that Karan was talking about, the committee, there is no clear guidelines. The guidelines are very broad, very vague. There is absolutely no timeline. You have not created any continuing mandamus here. And my comment on the previous, this aspect flowing into this one, could be that the committee will, even if they want to constitute a committee, right? Akai Padmashali and a bunch of people from working class queer trans persons and activists from Karnataka have written to the Prime Minister saying that please constitute the committee. Even if they constitute the committee, I'm sorry for being cynical. It might very well be just people who the government, who may be favorable to the government opinion, who have exactly what Mr. Tushar Mehta has presented, with all due respect to him, and will just frame a report and say that no, the country is not ready, the society is not ready. And then what do? Can you go back to court saying that the committee is not acting as per Supreme Court guidelines? I find that in environmental litigation, you have more, the Supreme Court has stepped in and made sure that committees actually work. In corruption actions, in violence that is broken out, as the Supreme Court should monitor, has done it. But in this case, it hasn't. So then I don't know. I really feel like transgender persons who are not queer, right, are fine. And then it's like creating a classification within transgender persons. And I don't, for one moment, I'm okay with it. I'm not okay with it.
Thank you for sharing your opinion on this, Kanmani. So would you say that this acknowledgement by the court of, by the apex court of the country of marriage being permitted under the current legal framework for transgender persons in heterosexual relationships, is this in any way a step forward from an earlier situation, or is this the same as before, but now the Supreme Court just acknowledged it? Would you say that this acknowledgement helped the transgender community in any manner whatsoever? Let's hear from Karan on this.
I mean, we'll have to see. We'll have to see. As Kanmani rightly pointed out, that as a country, we don't have a very good track record of the jurisprudence actually being implemented on ground. And as you know, like I have worked on criminal justice, and I've seen that DK Basu is hardly followed, or Hossein Ara Khatun is hardly followed. So it really comes down to the what is amenable to the discretion of the local level bureaucrats, officers, or the state government. So we'll have to see. I mean, did decriminalization of homosexuality led to no police violence or harassment to queer people? I really don't think so. So we'll have to see how much of it translates on ground.
Another thing that the judgment addresses is adoption rights for queer people, right? So the judgment has held that the rights of the majority opinion has held that there is no right for queer couples to adopt jointly. The minority opinion has held otherwise, right? So let's talk about how. So the minority opinion also interestingly has noted that there is no existing legal framework which would allow or permit unmarried queer couples to adopt and simultaneously ensure the best interest of children. So I think it's time that we talk about this aspect of the judgment as well. Aishwarya, what do you think about this?
So for me, this was actually quite an interesting part of the minority opinion, and I would say quite unexpected, because the commentary that came in during the time of the when marriage equality case was being heard was that the court would give a declaration of right to marry, but would leave these associated entitlements like adoption, guardianship, other financial entitlements, or next in privileges for future litigations. But the minority opinion surprisingly does not hold that there is a right to marry or whether the Special Marriage Act is discriminatory. So it basically keeps the queer couples outside the marriage framework, but still says that queer couples, like other unmarried couples, would have the right to, not the right, but the entitlement in a way to joint adoption, or they could adopt jointly under the current framework. And so right now, the adoptions happen under the Juvenile Justice Act. the juvenile, and there's much discussion and disagreement between the majority and minority as to whether under the Juvenile Justice Act there is a requirement that the couple who is adopting has to be married or not. The minority says that there is no such requirement under the Juvenile Justice Act itself, but the minority say there is no such requirement, but the majority says that the couple has to be married. That's the implication of the provisions of the Juvenile Justice Act, that only a married couple can jointly adopt. And then there are certain regulations that have come under the Juvenile Justice Act, which explicitly say that a couple who wants to jointly adopt, they have to be married for 2 years, and then there are other requirements. And now apparently there's a CARA circular also which says that if you are an individual who wants to adopt as an individual, you can't be in a live-in relationship. So you can see that there are various, exclusions that the adoption laws have made, where they have sort of put married relationship at the top of this hierarchy, and these adoption laws only think that only a married couple is suitable to adopt. So the minority judgment kind of goes against this idea, and using Article 14 and 15, it says that this assumption that the law makes that only a married couple can provide a stable household to a child, which is in the child's welfare. And because only a married couple can provide that sort of stability, that's what the adoption law says, that only because a married couple can provide the stability, this sort of joint adoption only accrues to married couples. And minority judgment goes against this idea and says that no, stability can come from different households. What is required for stability is a safe space and investment in running of the household by both partners, and that can also be something that is present in a household that is run by unmarried partners, including queer couples. So for me, this was interesting because adoption is traditionally what is understood to be a matrimonial entitlement, and that has now been delinked from marriage in the minority opinion. So I just wonder that whether this creates this sort of opening in future litigation where we can perhaps use Article 14 and also Article 15 specifically when it comes to queer individuals, as to whether we can challenge these laws that distribute entitlements and protections on marital basis, and say that, okay, this is not a reasonable classification that is made under law. And also unmarried people should also be entitled to these sort of protections and benefits that are being currently given to married couples under law. So that could be an interesting strategy to pursue. This would be a more piecemeal strategy because we have to individually challenge different laws that privilege marriage over other relationships. But perhaps this is more transformative and less exclusionary, as Karan, Kanmani have already talked about how marriage is heteronormative, it's founded in caste, it's even heterosexist. So there's a lot of baggage that marriage comes with, right? So maybe it's better to build coalitions with those who are unmarried and are also disadvantaged, are in the current state regime that privileges marriage. Build coalition with those people and now try to fight against this privileging of marriage under state law. So this is something that we can think about. And through this channel that the minority judgment creates. But of course, the majority kind of says that, okay, yeah, maybe there's a discriminatory assumption under the adoption law. But okay, we want to leave this again to the executive. So there's complete abdication by the majority on this point also. But I still think there is something to take away from the minority on this particular point of adoption. And it's delinking from marriage. Yeah.
Thank you for sharing your views on this, Aishwarya. Would you say that this considering married couples is a morally superior choice for adoption and other such things? Does that come from maybe the legal framework, the existing legal framework, or is it just because maybe the Indian culture is such that it considers marriage to be a more serious institution than unmarried couples or who are queer living together? Muskan, I would like to hear from you on this.
Yes, both. So all of the judgments, in fact, especially Justice Ranachud's Injustice, but go into the sort of historical analysis of marriage as an institution. And even when they talk about it, they talk about its emotional bond and intimacy and, the permanency that it gives people. There is little engagement with how heteronormative it is, with how it preserves existing caste class hierarchies, and what that means for the rights that the petitioners are asking for. So this was something we touched with in the beginning also, that when you are like, what is this judgment's conception or idea of marriage that the petitioners are asking for? So this privileging of marriage as an institution is something that is done, I mean, both in society and in the law. I think, I don't remember which judge talks about it, but they talk about how the right to family or is not necessarily a right that is in the constitution, like it is in the Irish constitution, for example. So this is not something that the constitution does, but this is something that the law has done. The reason why the petitioners submitted long tables of all of these entitlements that they lose, that they do not have access to because their right isn't recognized, is part of this sort of larger framework where institutionally, legally, socially, marriage has been given that privilege. And it's not possible to just engage with that or break all of that with this one judgment. It has to happen on all levels in a piecemeal approach. And even though this judgment, and it is a definite critique of the judgment that they do not engage with that. They do not engage with this problematic institution of marriage. But hopefully, the way that Aishwarya said, we can do that in the following judgments, especially given that this idea of classification of marriage is something that we see in X versus Principal Secretary. We've seen it with the unconstitutionality here, with the adoption guidelines. But then the reason why this judgment could also be a barrier then is because, for example, the majority judgment leaves this idea of whether being married or not is a good environment for the child up to the state. They say this is something we as the court cannot decide. State has decided that married couples are best for the child. So if in the end this court recognizes that constitution doesn't have a say in marriage, it's only the state who's going to regulate it and decide it, then how does that work for the future steps that we want to take?
Thank you, Muskan. I think that a lot has been discussed in this panel discussion. It's also interesting to note that the court had decided to exclude personal laws from the ambit of the proceedings. So while I invite all of your closing remarks on this, I wonder if this judgment could be seen as a way forward for the queer community to ultimately also legislate into personal laws and grant the right of marriage for the queer community in India? Or is it just, I saw a lot of people on Twitter just calling it a podcast, or how this could have just been an email. So what are your views on this judgment sort of charting way for the queer community in the coming days? Let's hear from Karan first.
I think one good thing that this judgment, not just this judgment, but the whole litigation, which I found very positive, is the visibility of the issue. I was very happy to see national media covering it being on the front pages of newspapers. Uh, the sheer excitement, or whatever intentions, but the sheer visibility of the issue was very important, because one of the problems that queer community in India faces is just the lack of knowledge that people have about the words or the identities or our desires. They just don't know the lexicon, or just don't know that there are other ways of living or desiring. So I think when it is out there on media and national conversations, then people are at least forced to notice. I mean, they may not form a positive opinion about it, but at least they will know what it is. That's how at least I got the way. I mean, I heard the word gay for the first time in my life when the 2009 litigation was going on, and that's when I was like, oh, that's what it is. That's this what. Then I started searching about it, and I was like, oh, this is what it means. So I think that's the only positive I see, that you cannot ask for recognition if people don't want to see you. If the polity and the state does not see you, as does not want to see you, you're not visible, you don't exist, then where is your politics? How will you exercise politics? So I think the only conversation starter or whatever few discourse builder exercise that I see of this judgment on litigation in general is that it has made us more visible. And now, again, like always, the burden lies on us in making sure how we leverage that visibility and use it to curate our own politics. So yeah, invisibility is what it did. I don't think anything else.
Thank you, Karan. I would now like to invite Muskan for her closing remarks on this discussion.
I think the judgment is really long. It's given a lot. Like Karan said, it's definitely started a conversation. There's also a lot to learn from the litigation process, what went wrong, and how as a community we want to do things as a movement, the political decisions that we take. So I think that way, of course, this judgment has been, this litigation and the judgment has been incredibly huge. I have all sorts of, like, we have trans people who do not talk about marriage, like ask us, what is this judgment? What has it said for us? So many people have came out after the 2016 Nafte judgment. So bringing this into conversation, talking about it is huge. But the sort of things that were said in terms of the fact that there's no right to marriage, that queer people don't deserve this, it does also have an effect on the ground. It is going to lead to police people saying that you can't live together. It is going to lead to further violence in terms of parents, in terms of peers. Just simply saying that, well, you shouldn't be discriminated against in the judgment, and saying, oh, we'll make a committee to deal with that, but not actually engaging with what that discrimination means and how the Constitution needs to go ahead and protect it, is a huge loss, because this was a constitution bench. There were more than 20 petitioners before the court. There was a lot of legal material. There is incredible jurisprudence of this court, and the potential for this could have been amazing. But it does have potential now for both setbacks and growth. And I think now it is incumbent on us as lawyers. There's going to be a lot of work on the ground level that's needed to see how we can use it to our benefit and how best to protect ourselves from the backlash that's going to then come from this judgment. So, I mean, we have what we have, and I think now it's about how we can use it.
Thank you, Muskan. Aishwarya, we'd really like to hear your closing remarks now.
Yeah. So I think the positive is that the court, I mean, majority and minority have recognized that the queer community faces wide-scale discrimination. I mean, that is a common thread in both the judgments. The negative is that the majority especially has chosen to do nothing about it and has left it to the executive now. But I mean, I have discussed, during this panel before, and I think I think what this judgment really tells us is that, how should we approach the court, right? I think it is for us to kind of reconsider that whether the strategy that we pursued was the correct strategy to pursue, whether we had, first of all, enough consensus within the queer community to, file this petition, and whether this petition was the petition that should have been filed, right? Because, or should we have, taken up a different approach of, challenging classifications based on marital status under a specific law, for instance, instead of just, going after marriage and thinking of it as this sort of gateway to all rights and entitlements that we want. And also kind of thinking about that, should we have kind of pursued another strategy about, this whole right to intimate associations beyond marriage? So, I mean, these are the things that we also see in the minority judgment. So it's for us now to reconsider our strategies as to what we really want and how should we get that. But I think one negative aspect, and I think Muskan also talked about it, I think the Supreme Court also has this agenda setting power. And in Naftesh, when it came out so strongly in support of the queer community, it set the agenda for the high courts, which also started very expansively interpreting the rights of the queer individuals when it came to the rights of queer individuals to live together, to be free from the violence of their natal families. You had the Madras High Court orders, which were very expansive. There were orders for reforming medical textbooks. So you saw all that development. But now the fear is that whether the Supreme Court has signaled that, okay, what we now need is more deference to the executive and less emphatic protection of queer rights. And we kind of saw a sample of that. And maybe this is just an odd decision, but recently Punjab and Haryana High Court said, there was a petition for protection of a lesbian couple that was filed, but the Punjab and Haryana High Court basically deferred it to the police to decide what sort of protection they want to provide. And this has not happened, right? This particular decision or order of the Punjab and Haryana High Court bucks the trend, where the courts have been very have come out very strongly in these protection orders. So, and despite the shortcomings of the protection orders, nonetheless, they have kind of explicitly held that under Article 21, there should be this protection of queer couples. So there's this problem of signaling, that what signal has the Supreme Court given with respect to the queer community to, the other organs of the judiciary. So, yeah.
Thank you so much, Aishwarya. Kanmani, we would like to invite your remarks now.
Every conversation I have on marriage equality for the past few months, including this one, has a lot to unpack, and I keep thinking all the different directions we are going to go in. What I would say is we have our work cut out now. We were, when the marriage equality judgment was, we were anticipating and we're thinking, oh my God, the amount of crisis cases that are going to turn up, people are going to want to get, people still want to get married, but people are going to want to get married at a greater number, and we're going to have to prepare everything. We were thinking, and now things are in a different direction. I would say, as a first year law student, when we had family law, we used to discuss the Hindu Marriage Act, and an amendment brought by the government of Tamil Nadu was the recognition for self-respect marriage, right? People keep talking about Saptapadi and everything, while self-respect marriage was like a very progressive step, and recognition for that was a very progressive step. So it's not that there are no way out. There are ways out. We are going to have to figure that out, sitting together as multiple stakeholders. And I also feel like, we have to think about, people who want to get married and people who don't want to get married, and rights for all of them, as Aishwarya and everyone pointed out. I do feel a bit disappointed. Having disagreed with the entire litigation, I feel very disappointed. I was looking forward to, as a trans person, and I do agree that this will, the Madras High Court orders given by Justice Venkatesh was like trend setting. It was like every hearing he was asking for, and I'm not saying that he's gonna go back, but I'm saying that I don't see if another high court will have, if this will happen in another high court. And the only small good things is they have talked about terminally ill, in the sense of the committee should go into that. I've seen cases where queer persons are not able to decide for their partners when they're terminally ill. And I would have really wanted the judgment in our favor, but it hasn't happened. So fragmented thoughts, that's all. The only one more bit is, I feel very disappointed that they have not gone into Rituparna Bora's petition in detail. That was by far one of the most consultative petitions that went into, in fact, a step ahead and talked about chosen families and not just about marriage. But yeah, that's all.
Thank you so much for sharing your views with us, Kanmani. And I think I really agree with you when you say that there is a lot to unpack in this conversation. But I would really like to extend my gratitude to all the panelists for joining us today. And I hope that all our viewers feel as enriched as I do from this discussion. Thank you so much for joining again. And I hope I see you in more such conversations about all other civil liberties that the Supreme Court decides upon. Thank you.
Thank you.
Thank you.
Thank you.